that those legalist accounts have is the question of infinite regression, right? So what is really the ultimate rule of recognition, and how do we know at each moment, right? Where does that rule come from? And this is why we need also all these political theories to somehow situate some moment of departure, right? Or some moment of beginning. And you're offering a very, very interesting element also, the workability of a constitution that reaffirms the legitimacy, right? Its legitimacy at each moment in history and how its meaning also evolves, right? So we probably need a combination of the two theories to make a better sense of a constitution. So, questions, comments, reactions?
Everything's right.
Well, I was tempted to observe that when you said the Irish view of the Free State Constitution, you meant the pro-treaty Irish view of the Free State Constitution, because Republicans of various stripes considered themselves to have an alternative legality in operation up to various, Corland, Jock-T, etc., and then Dev gradually disengages from that. So I don't know if you want to say a little bit about sort of non-state constitutionalism or alternative legality.
I take the point, but I don't really want to say anything about that. But I think you're right. It would have been more accurate to say sort of the official wisdom that had emerged by the 1930s about what the best explanation for that was what I was characterizing.
You mentioned the oath of judges to the Parliament in England and afterwards to the Irish government. Was that something to do with the oath that De Valera refused to accede to?
I just missed the first bit, sorry. I mentioned the
oath of the judges, or the oaths at different times. But at some stage, De Valera, I think it was maybe 1949, refused to take an oath of allegiance to English Parliament or to the Queen.
Yeah.
So well, indeed, when he set up the first Irish government or second one, yeah.
Yeah. So I think that's the oath of. I think what you're referring to, if I'm right, is the oath of allegiance that the members of the Oireachtas had to take to the English monarch, which was one of the provisions required by the treaty.
An oath of allegiance to the Constitution and an oath of fidelity to the monarch.
Okay, an oath of allegiance to the Constitution and an oath of fidelity to the monarch, and that was obviously what lay behind the refusal of Sinn Féin to take their seats. And then my recollection, and I'm sure there are loads of people here who can correct me, but it was De Valera with a mental reservation was prepared to take the oath of fidelity to the monarch. So sidestepped it, but it was one of the first things that he had removed from the Constitution using the constitutional amendment power after Fianna Fáil came into power in 1932.
Thanks to both speakers. I had two small questions for each speaker. Niamh or Oren might have something to say about this as well. When you mentioned Cumann na nGaedheal or Fine Gael figures later referring to the content of the democratic programme as not being properly a constitution, or this sort of thing doesn't belong in a constitution, presumably because it has a social element, or it is directive. It nudges policy or pushes policy in a certain direction, and there's, I suppose, a traditional sense that that's not what constitutions do. They coordinate institutions and they limit the power of the state. They don't direct the power of the state. And you suggested perhaps that De Valera and Fianna Fáil were more sympathetic in some sense towards this concept of constitutionalism. Is that kind of reflected in the constitution we now have, which kind of makes a sap towards socially directive constitutionalism, that there's some statement put in about principles of social policy, but they're non-justiciable, so it's not really sincere or it's not really meaningful. I just wondered if you had any thoughts on that as to what is the end product that we're left with. And for Oren, I was interested in your discussion of the unpublished provisions, the transitory provisions, and particularly the the idea that there was in fact authorization from within the old legal order for the new one. And do you have any thoughts then on what the political purpose was of having an optics of a break, if you know what I mean, and having the pretense of there being a break? Was there any necessity for that from a strictly legal validity point of view, just to make sure that there was continuity in the workings of the state, and that there was no, I suppose, challenge to the validity of the new constitutional system? Or was it simply political showboating? Was it simply a nationalist gesture to suggest, as De Valera did, that we are bypassing the lawyers and the whole order of legal validity, and we're going directly to the people in a new kind of constituent moment? Was that just all politics? That's all. Thanks.
No, I think the point you make about 1937 and De Valera's attitudes towards a social aspect of the Constitution are well made. I think there is very much a split between the two groups on what the role of the Constitution should actually do. And I think there is running through so much of the Cumann na nGaedheal in 1922, but sort of the attitude afterwards as well, of a very minimal state, and a state which should stand back as much as possible from intervention, I suppose, in an economic sense, less so in a moral sense. I mean, if we look at the kind of legislation that went on during the 1920s in terms of, licensing or, censorship or anything like that, there's a level of intervention there. But for the most part, there is a kind of almost Victorian attitude of having a very small state, and the state should not intervene in the economy or sort of in the laws as much as possible. And I think, we're hearing a lot about civil war politics and that kind of thing, but I think this is one of the sort of, rather than look at civil war politics in this through the prism of the actual civil war itself, the degree of interventionism versus sort of a willingness to enshrine these social kind of things is really what distinguishes between the two parties, I think, to a large extent. But I think, I don't know enough about kind of the Irish bar mentality or the kind of legal culture that existed around 1922. But I think I was reading something from Tom Garvin relating to 1922 about how the lawyers come in then, sort of, before 1922, it's the kind of the old Sinn Féin people, and then the Cumann na nGaedheal lawyers, the kind of Hugh Kennedy and all of these people sort of come in 22, and there's a new kind of, and I don't know to what extent that and the other thing have a sort of an influence on the thinking that sort of exists here. But there is very much, I think, an idea that, the Constitution is just like laws in a very sort of simple kind of way of setting up an apparatus of the state that is not part of certainly the De Valera mentality or the mentality of Fianna Fáil as a sort of a broader kind of a thing. So I think there are two sort of, now the extent to which Fianna Fáil ever tried to put the first democratic programme into operation is really quite negligible. But the fact that they sort of tied themselves to that mast, if you like, is, I think, significant in the way that sort of it operated or how it saw itself. So, yeah, I agree.
Thanks for the question. I think the provisions around Article 62 that I'm referring to, they didn't establish a chain of authority back to the Irish Free State, okay? But they just used some of the laws there to help the new constitution get off the ground in terms of having an electorate. But the new constitution was unconstitutional in terms of the Irish Free State, so it was a revolutionary act, okay? But I think that then is heightened on the face of the document, possibly for political optic reasons, but De Valera wanted to make it clear that it was a revolutionary act, that nobody could ever claim again that this Irish legal system traces its authority back to Westminster. It was designed to have a clear rupture with that. I think there was probably, and you see that as well, so that's Article 15 about asserting the Oireachtas as the sole legislative authority for the state is designed to ram home that point. And I think probably good reason to do it that way as well. You see lots of agonising with the other dominions of trying to work out, were they independent? Even Canada in 1980, people trying to work out, is Canada really independent or not? Because it hadn't had that sort of moment. So I think it served that clarifying purpose, which is probably more than just political optics.
Two hopefully reasonably brief questions. Well, firstly, for Niamh, it's interesting. Your presentation was fascinating, and the shift from Pearse's socioeconomic rhetoric, you know, the notion of, you know, the communal heritage of the Irish people and how we can dispose of private property in the interests of the state, and the falling away from that, so to speak, to the language of the 1920s, respect for property and so on. I'm curious as to whether there's been much written on whether this reflects a reaction to the October Revolution in Russia and the general sort of attention that happened all over Europe when suddenly sort of the vague progressive socialist rhetoric that had been very much in fashion before 1914 across wide swathes of sort of radical opinion, suddenly when faced with the crystallization of that in the form of the Soviet state, you see in Britain and elsewhere a retreat back to a much more cautious set of formulations. I wonder to what extent those international factors were in play, or whether in the Irish context those international factors were simply not in play, given the extent, given the domestic focus, inevitable tensions of our own domestic context. So that's a question to you. Question to Oran is, I've always been fascinated by this sort of doctrine of the questionable legitimacy, so to speak, of pre-1937 legislation. This notion that, you know, what became, you know, that sort of acts of the Oireachtas and acts of the Westminster Parliament before them, pre-1937, have sort of qualified assumptions of constitutional legitimacy, reflected in the sort of slightly incoherent doctrine of the sort of the presumption of constitutionality doesn't necessarily apply to 1937 statutes, and as I understand it, even less so to 1922 statutes, though I'm not sure if they've ever qualified that. That seems to me to be an interesting sort of carrying forward of everything that you're talking about into Supreme Court jurisprudence over the decades. And there's always been slightly unresolved issues there, which go right back to some of the tensions that you identified, and I wondered whether you had any views on that.
You raise a very interesting question about the impact of the Russian Revolution on the kind of the social thinking after 1922, and I think that it may have some sort of influence, but it's not really the substantive kind of thing that's in play here. I think if you look at some of the period of the we're talking about sort of from 1919 to 21. The dampening down of land agitation at some point prior to 1922 is already sort of happening, and I don't know so much if that's a reaction to what's happening in Russia so much as a sort of a innate conservatism on the part of some people who are already involved in it. But I certainly think that what happens after 1922 is that you have a group of people who are themselves of a more conservative point of view who come to the fore in the government, and I suppose they're in government on their own without the other wing, if you like, to balance them off. So they're in control on their own in a way that they wouldn't have been had, you know, the Civil War not happened and there had been sort of a less homogenous kind of a group actually in government at the time. So I think that the kind of ethos that emerged after 1922 is not so much a factor from what had happened in sort of the kind of the, you know, Russian Revolution and post-revolutionary turmoil, if you like, then just kind of Irish bourgeois, conservative, and for the most part sort of Catholic kind of point of view that kind of comes to the fore around that time. So they're clearly exercised by the Russian Revolution, the idea that, you know, calling Tom Johnson, accusing him of trying to bring in communistic doctrines and that kind of thing. And that exists all throughout the 1920s. But I think the main focus is really on trying to, you know, the people, I always sort of identify them with the UCD crowd, but the UCD crowd who were involved in all of this kind of thing, who did not fight for Ireland to establish an equal republic. They fought for Ireland to establish a UCD republic. And it's a very South Dublin kind of point of view. But I think that, you know, that's, you know, more than anything, that's what happens in 1922 and onwards. So, with apologies to my alma mater.
Don't think what my alma mater was up to in those years. But anyway, so Colm, it's an interesting question. There's certainly a lot of judicial comment to the effect that there's some heightened level of protection for legislation that was enacted by the Oireachtas post-1937, and there could be legal justification for that because they knew what the Constitution was, and therefore the idea that they were trying to conform to it is plausible. At the same time, it's very hard to pin down, is there any difference in approach? Gerard Hogan has said in one recent case that he can't perceive any difference in what he's meant to do as a judge.
Walsh was more keen on the current generation of judges.
Yeah, and also, there's a lot of legislation struck down, particularly the Criminal Law Act of 1935, but maybe that's just reflecting that the subject matter of that around sexual morality is one where views have changed so much that it's not that surprising that lots of it have been struck down by the courts. And I think there's also a counterexample that the courts seem to me to have a deeply ambivalent attitude as to what the Constitution was meant to do, because there's plenty of examples of them saying that because this was something that was happening before 1937, we must assume that they meant to preserve it. So it's very odd sometimes that the purpose of the Constitution was to change nothing. So if it was happening, the Constitution must have legitimized it. Now, of course, sometimes they do exactly the opposite, but maybe that just means that they're not thinking of such fine distinctions as you have raised and are ultimately deciding the case that they want and coming up with the reasons afterwards.
Other thoughts, questions, comments?
Thank you both for very, very interesting and stimulating papers. Just a brief comment on the question of equality, and that there is a reference provision in the Constitution to prevent religious discrimination, but it's worth pointing out that its origins actually are in Home Rule legislation, because there was a clause along those lines in the Home Rule legislation in 1912 and again in the Government of Ireland Act, and it was frequently referred to later on. The Government of Ireland provision was as a protection against discrimination in the north, though it didn't actually work that way. But a watered down version of this appears in the 1937 Constitution. But obviously its origins are very different from that of the Republic.
Well, yeah, that's absolutely correct, Son.
Other comments, thoughts? Yes, please.
So just to defend our colleagues in UCD and in the National University, it's really interesting to note that the only group that marched against the adoption of the 1937 Constitution was the Women's Graduates Association of the NUI, on a theory that, De Valera was on the record as saying, I believe in equality for women in the political realm. He had to, because that was established in 1918, the right to vote, but in no other circumstance whatsoever. And that's why the Women Graduates Association of the NUI including UCD, marched against it.
I'd just say that women in UCD are great. We're not the problem.
But in that context, Hannity Skeffington specifically referenced the population as being better protection.
And in the Dáil debates concerning the enactment of the 1937 Constitution, De Valera refers disparagingly to the lawyers and the obstacles the lawyers will put in our way. And I don't know myself, but to what extent did that reflect some cultural divide between Fianna Fáil and Fine Gael with the role of lawyers. Now we all know how prominent a role lawyers played in Fianna Fáil later on in history, but I think Niamh, you already referred to the influence of lawyers within Cumann na Gael, and particularly during the 1920s and in the years after the founding of the state. But was that mere one-off rhetoric on the part of De Valera when he disparagingly referred to lawyerly constrictions on the revolutionary moment of 1937, or did it reflect a broader cultural difference between the two sides of the Civil War?
Yeah, I think there probably is a cultural difference, or certainly in, I suppose De Valera, I mean, whatever about his mathematical thing and his penchant for drawing graphs and that kind of thing, would be more, would view the Constitution more in a kind of as you sort of said, a social kind of thing, or, he has a theory of society, I suppose, that he's trying to sort of bring about to a large extent with the Constitution, and that he's more inclined to maybe talk to someone in Drumcondra about it rather than someone in the forecourts or the law library. So I suppose maybe that's partly the kind of thing that he's talking about, and this kind of the issue with the legal thing is I'd be interested to see the sort of the history of lawyers in the two parties in the early part of the role played by them in the early years of the state, or even sort of thereafter. They tend to be associated more with the Cumann na nGael side, and obviously you've got people like Johnny Costello would be a prime example. And Johnny Costello, who was when he formed a government in 1948, was obviously the compromise from Dick Mulcahy, who was unacceptable to Republicans within the government. But part of the reason that Johnny Costello was so popular was because he had actually worked as a counsel for the trade union movement, and everyone knew him, and they'd gotten good legal advice from him and all of that kind of thing. But within that government, then you've also got in Clonmacnoise that you've got Sean McBride, and you've got Noel Hartnett, and you've got Con Lahan. So there's like a very strong legal basis in that side as well. So I don't know if that has anything to do with anything, but just I'm sort of thinking aloud here in terms of the role played by legislator lawyers within the state. I think that's kind of interesting. The extent to which obviously they're more, when they started becoming more apparent in Fianna Fáil would be a kind of an interesting sort of. If someone wants to write that, let me know. I'd be fascinated.
Though it is worth noting that many of those legislators and lawyers were actually held in common. Within the civil service, John Hearn is actually appointed by Cumann na nGael and is kept on by Fianna Fáil. So a lot of these lawyers, at least in the internal sense, in the civil service sense, are the same people. In the 20s and 30s.
I mean, I think it's interesting that one of the people who was kind of critical of some of the aspects of the 1922 Constitution when it was being drawn up was Alfred O'Rahilly, who's not coming from a law point of view, like he's coming from a kind of political philosophy, kind of thing. So I think there's a tension perhaps between the more legally minded people who are drawing up these things, and maybe the more kind of either clerical minded or political philosophy kind of minded people who are sort of also involved. So I think there's various different strands at work here that is kind of, if you sort of pull a string, I don't know what you're going to end up with, but, you know, it's kind of worth reflecting on. for
Just in
someone.
relation to lawyers on the two sides of the divide, I think Fianna Fáil was fairly deficient in lawyers at the end of the 20s. So Hugh Geoghegan has described his father, James Geoghegan KC, who was Minister for Justice and then Attorney General, as being essentially pro-treaty Fianna Fáil, in terms that Fianna Fáil needed a respectable legal figure who would sort of come on board and provide them with the gravitas, you know, and seniority in the profession. So
Actually, just to kind of link the two parts of that together as well, one thing is that the Professor of Constitutional Law in UCD, Patrick McGilligan, as late as the end of 1937, states in the Dáil, this constitution is only valid as an amendment of the 1922 constitution. It derives no authority from any other source. And apparently, I've talked to people who were students of his in the 1940s. He's still banging on about this, 10 years later, saying, well, it's really just the 1922 constitution. There is no break in the chain of, he refuses to accept any constitutional revolution has come. So you could see why somebody would be irritated by something like that, constantly coming at them from the opposition benches. So.
he was due actually to give a big public lecture in March 1948, I think, under the title Your Constitution is All Sail and No Anchor, but unfortunately he had to cancel it because he was Minister for Finance by that stage. So the government felt it wouldn't be appropriate for him, I think, to be giving public lectures about his views on the Constitution.
Do we have any other thoughts, questions, comments? Okay, it looks like we are right on time to finish the session then. Thank you very much. That was extremely interesting and complimentary, right, on both sides. And we're having a session in about 15 minutes on consolidation and conservatism and the Irish